Convener.
Thank you. Minister, come on yourself to respond. Thanks.
Thank you, Convener. I'd like to begin again by reiterating, as I did in Group 13, that I absolutely recognise the intention behind the amendments in this group in terms of seeking to reduce the trauma experienced by those who lose a child as a result of crime, and again understand Ms Maguire's motivation for lodging them. I reiterate again that the Government is committed to considering this issue in more detail and in discussion with those with lived experience. But yes.
Is the Minister able to confirm my earlier point in terms of equitability between representation from victims' groups and those of the accused at said round table? In other words, I appreciate and agree that the Government will clearly give consideration to it, but I just want to flesh out the nature of that consideration, that it will be equitable because of the challenge of balancing rights, which I think my colleague Ruth Maguire alluded to in the earlier grouping. Thank you.
I'm going to address that in just a wee second. Thank you. So again, sorry, just reiterating the commitment to considering this issue in more detail, and appreciate Ms Maguire's comments around wanting to see action on this and not just discussion. And I really do believe the steps that the Government are taking are leading towards that. In terms of the round table, it is focused on deceased victims. As far as I am aware, I believe that victim support organisations will be at that round table. However, it's not myself that is organising that. I'm more than happy to seek that information and provide that to the committee in terms of who will be in attendance and who will be contributing. However, to continue, I just want to reiterate my comments around the potential for unintended and adverse consequences that could impact negatively on the very people the amendments seek to support, as currently drafted, which is why, as I've said, the Government will work very, very closely with Ruth Maguire and other members as we consider these matters fully. So I'll turn first to Amendments 124 to 136, which, taken together, seek to extend reporting restrictions in relation to publication of information which could identify deceased child victims of a crime and their families prior to any court proceedings, so providing a right of anonymity. As I said, I have concerns regarding how certain aspects of these amendments could work in practice. For example, they would require bereaved relatives to go through the emotional and financial cost of applying to a court to be able to publicly identify their deceased child as a victim of crime. It could also risk criminalising, for example, the child's peers who wish to publicly express their grief at the loss of their friend in such terrible circumstances and who may not understand that there are any restrictions.
Just on that point about peers, aunties, social media.
Convener, yes, I've gone against my taking interventions at the end, which I will return to, but I'm happy to take.
I'm going to permit intervention on this. Okay.
Thank you, Convener. Forgive me for that. I understand the line that the argument that's being put, but surely if we think about rights and children's rights, we're not suggesting that a cousin or a friend, their right to broadcast their feelings about the deceased is more important than the family of the deceased, not their right to privacy in a family life. It's a challenge. It's not really.
It's absolutely, it's a challenge, and I think that's why I've committed to further discussion on this, because we have to overcome those challenges. It's not about putting importance over one sort of member of a family over another. It's just about considering how we get this right, I would say. It's essential, following on from that, it's essential that we learn from the experience of other comparable jurisdictions who have had to actively amend or repeal legislation on anonymity for deceased victims following changes made at haste and without proper consultation with all those affected. Bereaved families in these jurisdictions, for example, Ireland and Victoria, Australia, have likened such laws to gag clauses and expressed anger at not being able to speak freely about their loved ones. Another concern is the potential for anonymity for deceased child victims to operate as a shield protecting the the identity of those who are committing or commit offences. And it's hard to understand, as I said in the previous grouping, how you could identify one at times without leading to the identification of the other. Again, something that needs considered further. It's also unclear what would happen where there was not a consensus amongst family members as to whether an application should be made to the court seeking to dispense with reporting restrictions in respect of a deceased child victim. Amendment 131 enables a broad range of family members to apply for such a dispensation, including a parent, sibling, child or spouse or civil partner of the deceased child victim. Not all bereaved families will have a unified view on whether they wish the identity of their bereaved child to be made public. One family member may wish the child's identity to remain anonymous, whilst another might wish to speak publicly about the child, whether it to be to remember and celebrate their life or to raise awareness and campaign. It's hard to envisage a non-traumatising process by which family members would have to apply to court and argue either for or against the waiving of anonymity. Amendments 139 to 146 are along a similar vein. By seeking to extend reporting restrictions in relation to publication of information which could identify deceased child victims of a crime and their families once court proceedings are underway. The issues I've already outlined apply equally to these amendments. In relation to Amendments 152 to 154 concerning the Court's powers in respect of the retrospective removal or reinstatement of published information which wasn't subject to reporting restrictions at the time it was published, I have concerns about how these could work in practice. And I will not reiterate what I've already gone into for Amendments 137 and 138 in Group 13, but I do have the same concerns about how these amendments would work in practice and the enforceability, which would impact upon the benefits they can bring for those whom they seek to aid. Again, I will, however, reiterate what I said in Group 13. The Government is keen to seek a solution to the issues raised by bereaved families and victim support organisations and to engage on those in an open-minded way. But it's essential that we fully explore those complexities involved to avoid those unintended consequences that I've alluded to this morning. I note this issue has potential implications too for the Vulnerable Witnesses and Justice Reform Scotland Bill, which also includes provisions about reporting restrictions for the protection of other victims of offences under that bill, and that's currently at stage 1. As I mentioned before, the roundtable event with a range of partners in February will provide that crucial forum to discuss experiences and options, and the Cabinet Secretary and I are absolutely committed to work with Ms Maguire and any other members on this matter. For the reasons outlined, I am therefore unable to support the amendments and again would urge the member not to press in return for a commitment from the Government for discussion and engagement on this extremely important issue, allowing time for the level of detailed consultation and consideration that this important and complex matter warrants beyond this bill.